All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. This is a special sitting. We have one case on the calendar this morning, Kevin Thompson versus United States. Counsel, we're ready to proceed. I assume you are. Ms. Schneider, you may begin.
Thank you. May it please the court, Stephanie Schneider on behalf of appellant Kevin Thompson. I'd like to reserve 2 minutes for rebuttal today. At the outset, I want to clarify Dr. Raffanello's opinion. She opined that JF's mental health records were consistent with untreated PTSD and included symptoms not fully explained by her SSD diagnosis, including a history of childhood trauma, documented flashbacks to a prior rape, multiple rule-out PTSD diagnoses from doctors who also suspected PTSD, and tactile hallucinations during an emergency hospitalizations 6 weeks before the incident in this case. Based on this specific medical profile, Dr. Raffanello opined that it was possible JF could have experienced a flashback to the prior rape during her sexual encounter with Mr. Thompson. This opinion was rooted in JF's history and symptoms, Dr. Raffanello's vast clinical experience treating PTSD, and a wide body of research literature. Her first opinion that JF's records were consistent with untreated PTSD was reliable as a matter of law. The underlying principles about the symptoms, diagnoses, and treatment of PTSD, and the challenges of assessing and diagnosing someone who was also acutely psychotic in an emergency setting were largely undisputed. Her methodology, a comprehensive assessment of the medical records based on her education, clinical experience, and the research literature, is routinely admitted in courts applying Rule 702. What was in dispute here were the conclusions that the experts drew from the records, but that was not an appropriate basis to exclude the testimony under Daubert and Motorola. And I really want to underscore here that her treating physicians suspected PTSD in the months leading up to the incident and repeatedly flagged it for further evaluation. On November 5th, 2015, she receives a rule-out diagnosis of PTSD during outpatient treatment in Pittsburgh following an emergency hospitalization. On January 5th, 2016, and again on March 24th, 2016, her providers note that trauma-associated psychosis may factor into her presentation, but she never receives that PTSD assessment because she routinely missed her appointments. And the focus of the few outpatient appointments she attended was on getting her to restart the medications that she had discontinued and on stabilizing her psychotic symptoms that had reappeared when she came off her medications. And Dr. Raffanello was very clear.
I mean, that's a fair bit of information to support the idea that there is at least some possibility that there was undiagnosed PTSD or subsyndromal PTSD, a related but distinct idea that was discussed in the testimony. But I want to make sure, is it accurate that with respect to the testimony at the hearing, there was no effort to elicit any assessment of probability rather than mere, I don't mean mere in a dismissive way. I just mean nothing more than possibility without any further indication of where on the spectrum of possibility that possibility would be. Is that true? Is there nothing that is, it's not merely, 1 in a million possible. It is, there's pretty good reason to believe. Is there anything in the record that would tend to support a stronger sense of possibility rather than a weaker sense of bare possibility?
Sure. So, I mean, certainly wasn't like a numerical probability that was elicited. And I think we've put a lot of case law that that's certainly not required for psychologists and social scientists. But in terms of what is meant by possibility, which is, I think, what I understand your question to be, this was not a theoretical possibility that she had a flashback, right? So it's rooted in these symptoms I've just described. And I think when she uses that word possible, it has to be understood in light of Dr. Raffanello's background as a clinical psychologist who advises patients about real world possibilities of a condition. When she says it's possible JF had a flashback, it means that in her experience, right, someone with JF's unique medical profile is susceptible to flashbacks, right? There's a reasonable or realistic possibility she could
Well,
have.
again, I mean, that's all your inference, I guess. There isn't any explicit testimony, I'm gathering, where words like realistic or significant or substantial or any of those other non-quantitative but still strengthening adjectives were used. Is that accurate, or is there something I missed?
I don't think there was a specific adjective that was used, but I think when you look at the testimony as a whole and you look at what she's relying on and you look at, the symptoms she's pointed to, that history of flashbacks, I mean, she makes clear that she's relying in part on the history of not just the history of prior flashbacks to a prior rape, but also the timing of those tactile hallucinations that occurred just 6 weeks before the incident in the case. She's drawing from her experience, right? Treating patients who have similar medical profiles and who have had flashbacks. She talks about patients, right, who, have had flashbacks during consensual sex to a prior encounter. And it's in light of this review that she's testifying, right, that it's possible. I think what she means is that JF, based on this medical profile, is the sort of person who is susceptible to them. Certainly she's not, and I want to be clear about the scope of her opinion. She's definitely not trying to opine on what did or did not happen, right? That was not the opinion that was elicited. The opinion that was elicited is to talk about sort of the possibilities for someone with this unique medical profile, with this history, with these symptoms, who hasn't received treatment. And so she said, she says this is possible. This is what I see happen, in the real world. And I want to underscore that the word possible is used by experts, all the time. Psychologists testify about the possible effects of certain factors on an eyewitness identification. They testify about the possible effects of medication. I mean, this is something that is done, frequently, in the field.
Do you think it would be, I mean, imagine in any case that turns on eyewitness testimony, that the defense proposed to call an expert, and the expert would say, would be asked, is it possible that someone could have a hallucination and could confuse reality and the hallucination? And the expert would say, yes, that's possible. Would that be admissible testimony? Because it's possible. Now, it's not tied to it's different from this case for sure in two respects. One is it's not tied to anything specific about the eyewitness. The other is it is kind of wrapped into the circumstances of the incident. Would you agree, though, that testimony like that tied in neither way to the case would appropriately be excluded by a trial court?
Yes. I mean, I would agree with that if the testimony were just based on some random person on the street, it's possible that they could have some condition that we don't know about. And yes, I agree that that's sort of the theoretical possibility. And I would agree with that statement. But this isn't that, I think, as you've alluded to. It's not just based on what's the statistical probability that a random person on the street could have PTSD and could have flashback. I mean, that's not what this is. This is grounded in specific medical records that she has reviewed, as an expert who focuses on PTSD and trauma. And she sees all these markers, right, of PTSD that other providers see too. And she also sees them very close in time to this incident. I mean, 6 weeks earlier, having tactile hallucinations is very close in time. So this is not, even talking about somebody where it's, years ago. This is information that is informing her. And she's also bringing to bear on this her vast experience treating patients, how flashbacks can present themselves, when they can occur, the research literature.
What you just said about how flashbacks can present themselves leads me to a concern about this case that I wanted to ask you about. So in asking the hypothetical I did, I was acknowledging that it's different from our case in two respects. It's not tied to circumstances or attributes of the eyewitness, as the testimony here was.
Mm-hmm.
But it's also, I was suggesting, not tied to anything about the circumstances of the incident. And I guess I'm interested in the extent to which it is significant here that the opinion wasn't tied to the circumstances of the incident in some respects now, and maybe in some it was and in some it wasn't. So, and so let me, I guess, give you a hypothetical. Imagine that I mean, this is kind of a silly hypothetical, but imagine there's a car accident. And the question is whether it was the result of an accident or a result of intentional, assault by the driver. And imagine that the defense wants to put on a witness that would say it's possible that the car had a mechanical defect, and looks at the treatment records of the car and doesn't examine the car. Analogy here, because there was no direct examination of the witness, and so isn't able to say, well, yeah, I've looked at the car and I can definitely tell the brakes weren't working before the accident, but can say I've looked at the records and it is possible that the brakes weren't working. But imagine also that the circumstances of the incident, if you actually then go look and see what happened, there in ways that would be undisputed if an expert looked at them. It would be clear that's just not possible. No expert would look at the circumstances of the incident and say that it was an accident. The people actually looked at the brakes after the accident, and the brakes weren't damaged. Would you agree that an expert opinion that is to a degree rooted in some of the circumstances, but doesn't take account of other circumstances that the expert might well acknowledge, or it would make what was possible on partial knowledge impossible on full knowledge in the expert's opinion? Would you agree that evidence like that can be excluded?
So I think that's sort of a different case than we have here, and that may well be like a weaker case. I want to emphasize that is not really analogous to what we have here, and the reason it's not analogous is because I think, at least as I understand your hypothetical, what you're saying is, looking at those real world circumstances of the incident, everybody would agree, right, that an accident couldn't happen. This is actually quite different. I mean, this is a situation, right, where Dr. Raffanello is aware of what happened, in particular because she reviewed Dr. Satoff's report, right? She reviewed his report where he describes in great detail, the circumstances. It does not change her opinion. She does not retract her opinion or say, I can't offer a medical, an opinion based on that. And I think the reason is because there was a lot of testimony, right, from both her and Dr. DeWright about the fact that somebody, repeatedly says what happens the same way, or can articulate what happened, and be sort of in the present time, doesn't really tell you whether or not there's a flashback. And that's because, I think Dr. DeWright said it's quite common, right, that somebody who experiences a flashback will encode that flashback as their memory. And then they will repeat that, as their memory. Now, obviously, some people can differentiate, particularly if they've had treatment, they have more insight. If they have somebody else who was there and say, no, that's not how it happened. What you're saying doesn't make sense. But that's not the facts of this case, right? The facts of this case are she comes home and she does repeat.
As you're probably inferring, the aspect of this case that I find somewhat troubling about that, excuse me, are the indications that Dr. Raffanello had requested information about kind of the circumstances of the incident, including materials like the 911 call or other things that might well be relevant to whether you would assess what happened then as consistent with someone who was in the throes of hallucination, unable to distinguish between reality and a flashback. I use the word hallucination, flashback may be more precise. And acknowledged that would have been helpful and was not provided it for reasons that don't seem to be clear in the record. And that seemed to trouble the trial court. And I guess I'm wondering why you don't think it was reasonable for the trial court to be concerned that admitting an expert ultimate opinion about, well, it is possible that what happened on this day was a flashback, from a witness who hadn't seen information that the witness said would be relevant to that assessment, and for reasons that don't seem to be explained or clear in the record. Why wasn't the trial court right to be concerned about that as relevant, as significant in making an admissibility determination?
So I think there are a couple of responses. First, I think when she's asked on cross, she says, it might have been helpful, but then she sort of clarifies that a little bit later. And it makes clear that, it might have been helpful, to know the facts, all the evidence, all the trial evidence, if she were the trier of fact. And she goes on to say, like, my role here was to talk about the possibilities, what they would be for someone with this sort of diagnosis of those types of symptoms. I don't know what happened. I wasn't there. And I don't feel it's my role to opine as to whether or not the event occurred the way either side is positing. And I want to say, I think there's good
I mean,
reason for the
distinction.
defense.
all that is
There's a
true.
distinction between saying, I'm not going to opine as to the event that occurred, or whether she is credible, or whether the complainant is credible or not. There's a distinction between saying that and saying, but I am interested in knowing whether the facts and circumstances surrounding the event are suggestive of impairment or not. And it seems clear that Dr. Raffanello wanted that information, and that the defense told her she couldn't have it. And I don't think it's a satisfactory explanation to say that Dr. Raffanello was not going to be offering an opinion as to what really happened, or as to whether JF was credible. And indeed, I really wonder if once the jury at a trial heard from the witness's own mouth that she wanted that information in order to formulate her opinion, and that the defense declined to give it to her and said, well, just make your opinion without that information. That would, to my mind, most jurors, maybe all jurors, would say, well, that's it for me. I'm not crediting that at all. I think that has a devastating effect on the introduction of this witness's testimony and its credibility before the jury. So if we're thinking in terms of Rule 403, even if we get past Rule 702, I'm interested in your response to what seems to me a very gaping problem for the defense.
So a couple of responses. I think it was perfectly appropriate to elicit a records-based opinion. That was what was proffered below. That was what was proffered to the Court of Appeals on appeal that we were going to do, and that was also, what was.
But
in the
she's doing
expert
more.
note.
She's offering an opinion that there was a reason, that there was a possibility that during her encounter with Mr. Thompson on this particular occasion, she had a flashback, and that the flashback was of such a nature, it is possible, that she could not even recount accurately what really happened between her and Mr. Thompson, and in fact created a story that wasn't true. That's a big sell and a big leap. And when the witness is asked, well, did you bother to look and see, what the witness actually said, and her state of mind when she said it, and how she appeared to people, and how coherent she was, and all the rest. And the witness has to say, well, no, I didn't. I wanted to, but defense counsel wouldn't let me look at it. That strikes me as a big problem.
So, I don't think that's quite a fair reading, of the record, right? What she is testifying. First of all, she doesn't sort of spell out all of that. Her testimony is largely about the records and how it's consistent with PTSD and somebody who has had flashbacks, right? And I think based on that alone, right, we would have been able to put on evidence about PTSD and flashbacks generally. Then what she says is that it's possible.
It's all irrelevant unless a conclusion can be drawn that there is a reasonable probability that at the time of the encounter, JF had a flashback, and that the flashback has impaired her ability significantly to recount what really happened.
And she is testifying based on the records that is a possibility for this defendant, right? She's susceptible to flashbacks. That's what the statement is, that it's possible she could have had a flashback, based on her constellation of.
Can I drill down right there? This is where I get confused, because I think that she has testimony about what's possible, and it seems like the word possible is being used in perhaps different ways at different times, right? So if we look at the expert disclosure, the expert notice doesn't say anything about the expert testifying about what JF was thinking or doing, or how she was acting or reacting on the date of the incident. right? Doesn't say anything about opining that JF had a flashback during the incident with Mr. Thompson. It's much more general to the point that JF possibly had PTSD, was experiencing flashbacks around the time of the incident. And there's testimony from the expert to support that at the hearing that that's possible. And I understand from your conversation with Judge McLeese that when the expert says possible as to those phenomena, the expert is essentially saying there's a reasonable alternative explanation for her mental health, right? That she doesn't just have SSD, that she actually has PTSD with flashbacks that is active around the time of the incident.
Yes, that's correct.
Okay. Then there's the separate issue of what the expert says about the incident. And the problematic testimony, I think it's on page 53, where the expert is asked, you know, is it possible that she had a flashback during the incident? That she had a flashback to the sexual assault she experienced at age 14 during the encounter in 2016. And the expert says it's possible. And then that becomes sort of a flashpoint of the hearing. And Dr. Raffanello is asked repeatedly about that. And I'm looking on page 127, where she's asked, you know, you're not aware of any evidence that suggests that JF actually suffered a flashback on the specific date. And she says, I have nothing to believe that, right? So unlike the testimony that that JF has active PTSD, either undiagnosed or subsyndromal, that she is experiencing flashbacks around the time of the incident, it seems like the expert is differentiating vis-a-vis the date of the incident and saying, you know, to the extent that she said that that was possible on page 53 of her testimony, that possible is kind of based on, well, sure, maybe, but not really founded in any factual information. And I'm wondering, do you see that distinction? Because if you're telling me that all of those possibles are equivalent, then the possibles seem to have very little meaning. If you're telling me that the possibles as to the PTSD, missing diagnosis or subsyndromal situation, that means it's a reasonable alternative explanation, that seems grounded in the medical records. But I think that seems distinct from the testimony about the actual incident.
So I would certainly agree with you, right, that the testimony about, you know, her records being consistent with PTSD and the type of PTSD where somebody has flashbacks, that is, I mean, I think that is stronger testimony, sort of, it's for sure. But I think the issue here is what is really meant by that statement, that it's possible that she had a flashback on that day. And I think what's going on is she's saying that for somebody with this profile, like they are susceptible to flashbacks, like they are not like a regular person walking down the street who's, you know, never going to have a flashback. They are susceptible. They may have a flashback, particularly, you know, she tied it a little bit to consensual sex, having had patients who have had a history of.
She might be susceptible to getting them, and the records might support that around that time. But it seems to me the expert herself admits on the stand she has no basis to say that she actually had a flashback during the incident. No basis other than to say that she's generally susceptible around that period of time. And so why isn't it true that that statement is a bridge too far, right? That maybe everything else is supported and admissible, at least under 702, set aside 403 for a second. But that under 702, the statement that it's possible that she had a flashback during the incident with Mr. Thompson is just not factually supported.
So, I mean, we think that because she's susceptible to it, it's possible, but I sort of understand your concern about it. Is that going to, be confusing to the jury? And so I do think there's a world, let's say under 403, right, where the judge can say, I'm going to let all this, the first part of the testimony, come in. And then, and I don't like the way you're asking that question. I think that's going to be sort of confusing if what you're really saying is this is a person who's susceptible to flashbacks, unlike just a regular person. This is somebody who's susceptible. I want you to ask that question in a different way, maybe as a hypothetical, would somebody with this profile,
I'm just going to push you again on, I'm going to push you again on the 702 part of it, though, because it seems like the cases that you all are citing, Polk and I'm blanking on the other cases, Christensen, they seem to draw the line that I'm drawing to say that it's okay to have an expert based on medical records testify about the current, the mental health situation of an individual around the time of the incident, but it is a step too far. It is unsupported for that expert to actually opine as to the mental state of the individual at the time without having reviewed the case records or spoken to the individual about the incident. Unless they have that sort of foundation, those cases seem to say that you have to stop short of that under a 702 analysis, not even getting to 403.
So, I would agree with you that the expert can't opine about the actual mental state of the person at the time. But I guess our position is that isn't what she was doing. I mean, I think if it seems like that question has created a lot of confusion. And so certainly there's a world in which the question, the judge could say, I think that question, the way it's being asked is creating confusion. Don't ask it that way. Because I don't think it was intended to be an opinion that she actually had a particular mental state. It was intended to be.
I mean, the question is at the bottom of 52, top of 53, is it your opinion that JF could have had a flashback to the sexual assault she experienced at age 14 during the encounter in 2016 with Mr. Thompson? Right. Now, that question seems to come out of left field because it's not part of the noticed expert testimony that PDS gave the court and the government, right? There's no indication that the defense is going to ask that question. But the expert answers it. There's no objection. The expert answers it, says it's possible, and later indicates that she didn't think that she was going to be asked that question. I'm looking at page 106, right, where she says she's being asked about why she didn't look at the records. And she said, well, I was told that my role was to opine on whether the individual had symptoms of PTSD and what that might look like and what the treatment would be, right? Not about whether or not she had a flashback on the date of the incident with Mr. Thompson.
So that question may have been, inartfully asked. I mean, I think what was intended by that question is what was in the expert notice was to test, the possibilities of exactly what you just read. She was testifying about the possibilities for someone with a specific medical profile. I mean, I think, certainly there's a world in which the judge can say, I'm going to let in everything, but I think this question is creating, confusion. I think she's intending to say, I think given her later testimony, what she's trying to say when she answers that question and says it's possible is she's trying to talk about the possibilities for someone with that particular medical history. It seems like the phrasing of that question has sort of tripped up, this whole hearing, but I want to underscore that is not a reason to wholesale exclude an expert testimony because the question was inartfully asked.
Go ahead, Judge McLeese.
You're muted.
You're muted.
Excuse me, I apologize. I know this is not the record in this case, but imagine a case sort of like ours, but different in a critical respect. Imagine that the testimony on the first two steps of this kind of chain of reasoning was similar. So the expert says, I've looked over these medical records and there are, and imagine it was stronger. It's like there are a fair number of signs of possible PTSD. So I think there's a significant possibility that there might be undiagnosed or subsyndromal PTSD here. And imagine at the second stage that the expert was testified one symptom, and a not uncommon symptom of PTSD or subsyndromal PTSD consistent with what I see in these records is flashbacks where the person experiencing them is unable to distinguish between reality and the flashback. But imagine also that the expert, it was clear and undisputed that the expert really didn't know what happened at the incident. And the expert would say, when asked, I have no idea whether in fact there was, what happened on this date was such a flashback. And the reason I don't is because I haven't looked at the undisputed facts. I haven't looked at like 911 calls or other information. And that might well tell me whether that is or isn't possible. If I looked at those materials, I might well end up concluding it's not possible. On the other hand, if I looked at them, I might end up concluding it is possible. I don't know. So I have no opinion whatsoever about whether on the date in question, there was or was not a flashback. Assume that the record was like that. Do you think the trial court would be obliged to permit that expert testimony to come in? And if so, why? If there's no one who is saying, it's just an odd form of evidence. It is something is possible if I look at half of the evidence, but I haven't looked at the rest. And I admit that if I look at the rest, it might well be impossible. I don't know. Is evidence of that form properly excluded or not? It seems to me that perhaps it would properly be excluded.
So under your hypothetical, if the expert, herself is saying, I can't opine, on what is possible for this expert without, reviewing trial facts, maybe that's.
Well, you said trial facts. I'm quite sure what you mean trial facts.
So what they gave, I think sort of the point of dispute here is what Dr. Satoff does is when he writes his expert report, he says, what I am looking for is evidence of whether there was a complete loss of total awareness, which is, as the DSM-5 said, that's like one spectrum of a flashback. The most extreme version is you are disoriented in time and space. You don't know where you are. And so he says, I'm going to look at the records. I'm going to watch the body cam. I'm going to look at the 911, listen to the 911 call. I'm going to review. He's actually reviewing trial evidence of the testimony of the mother and the brother. I mean, he's like literally reviewing all of the trial evidence. And he says, what he's looking for, at least according to his report, is this sort of total loss of awareness, one spectrum of a flashback. And I think what he's saying is, I don't see evidence of that most extreme form. But what you've also heard testimony about from Dr. DeWright and Dr. Raffanello, and it's in the DSM-5, is that's the extreme form. It's very common, right, that somebody has a flashback and they don't, they sort of confuse that flashback with reality, but they are still able to get home. There was an Afghan hypo that was given repeatedly where a veteran from Afghanistan comes home, they hear a car backfiring, they have a flashback to sort of the prior trauma from the war, but they know they're in DC, they're able to run home, but they sort of they hang on to this belief that they were shot at, even though any other person would know that there was no gun fired. And so sort of the two are jumbled together and they may maintain that belief repeatedly over and over. So Dr. DeWright is given these hypotheticals. I think that the government doesn't push Dr. Raffanello on, would this change your opinion? If you knew this, would you change this opinion? And they don't push her on that because I think they know that I think they probably know her answer is that, no, it's possible for all these reasons that's of limited utility because of the way most flashbacks work, not just the most extreme version. And in fact, when they push Dr. DeWright on it, they give him hypotheticals. They say, well, what if you knew this fact? What if you knew that fact from the trial evidence? Wouldn't that tell you that there's no world in which there's a flashback? And he says, no, it doesn't really tell me one way or the other because it's so common that people sort of imprint that false reality as their own. And they repeatedly, say it over and over again. And yes, it's very common that somebody has a flashback, but they still know who they are. They're still able to, get home. They're still able to give a coherent account. And so I think that's really the disconnect. Like Dr. Satoff is looking for something different, the most extreme form. I think you have Dr. Raffanella reviewing Dr. Satop's report, and she wasn't asked to do that because she wasn't asked to opine on what actually happened, which frankly we think is a little improper to be asking the expert to review, all of the, reading testimony from the trial and all of it. But
Gee, experts do that all the time. That's how they perform their function. But let me ask you this question. So if I understand correctly, the jury would hear from Dr. Raffanello something along the following lines. There are indications there are indications that JF might have suffered from PTSD. I cannot make that diagnosis, but she might have. There are indications of that. And there are indications that she might have been having flashbacks around that time related to her sexual assault when she was 14 years of age. Now, if that's all the jury the jury hears, what is the jury supposed to make? How is the jury supposed to evaluate that testimony and decide whether it has any bearing on what happened in this encounter with Mr. Thompson?
so
If the expert herself can't make a determination that there is a conclusion that there is a reasonable possibility that JF suffered from a flashback that impaired her ability to recount accurately what happened.
So I think this is the
How
answer.
is the jury supposed to deal with that?
Sure. So, the one other piece of information that I would add on is it's not just, flashbacks. She's had flashbacks, to a prior sexual assault. But yes, so to your point, when they are evaluating, they're going to look at all the evidence from the case. But I think what's going to be different now is there was a lot of evidence, right, in this case that was kind of odd for a sexual assault and consistent with a consensual sexual encounter, right? No neighbors heard screaming, despite.
That's very interesting because my reaction was there was no evidence at trial of a
So sure.
consensual
Why
sexual
don't
encounter.
let me just walk through. So I think without the testimony, right, it may seem more improbable, but let me just walk through some of the things that were, inconsistent, and then how that might be in a different light if the jury had another possibility to consider as they were trying to figure out what happened, right? So no neighbors heard screaming. She says, I'm screaming before, I'm screaming during, there were lights on, there's no evidence that anyone heard screaming. She had no significant injury. There were elements of her account that didn't really make sense and seemed very odd for a rape. She's testifying that Mr. Thompson is like putting a shirt down for her to lie on so she can be more comfortable. She doesn't, she testifies that she interacts with Mr. Thompson for 5 minutes in the street and she has her phone out, but she doesn't actually call 911. She doesn't run to her neighbor's house. It's things that you would think she would do if she was actually scared the way she's testifying she is. Mr. Thompson shows no consciousness, of guilt. He doesn't run when he's confronted by the mother or the son or the passerby. He cooperates.
He tells a lie to the person who speaks to him.
So I think how you
lie.
I think without the evidence of the possibility of a flashback, right? The jury is left with sort of like two choices. Is she telling the truth or is she lying, right? And the jury's going to think, I have no reason to think she's lying. And so then they're going to see that statement, right? Maybe that statement to them, supports it, but that's how they're going to view it. She has no reason to lie. Why would she lie? There's some inconsistencies or some implausibilities. I'm going to just chalk that up to the fallacies of memory because they haven't given me any reason why she would lie. If they knew about her history of flashbacks and recent ones at that, and they knew that she had previously had flashbacks to a prior rape, the jury's going to have like another possibility that they're going to have to consider as they evaluate that evidence. And
I'm asking you how they consider it. And I'm asking you how the jury, given what little they know, would consider that. I mean, it looks to me like pure speculation.
Well, I think they're going to have to, I think this is what it's, this is what it's always like, right? When you have, let's say, eyewitness testimony, an expert comes in and says it's possible that the presence of a weapon, presence of a weapon
does more
could
than
affect.
That. But the expert in those cases does more than that. The expert in those eyewitness cases says, I'm talking about the circumstances that were present at the scene of this crime at the time it occurred. There was a gun. the lighting was X. The circumstances I understand are that the victim had never seen the person before. The expert applies the knowledge of research to the facts of the encounter to explain why that research is relevant and how it may have a bearing. That's what seems to be missing from the proffered expert testimony here, and that's why I'm asking you how a jury hearing these possibilities is supposed to make any sense of them, and other than to speculate. Well, it is possible. Well, anything is possible.
Well, I think I think the similarity, what they have heard from Dr. Raffanello is based on her medical history, right? Based on those tactile hallucinations 6 weeks before, based on, having had flashbacks to a prior rape, based on these rule out PTSD diagnoses so close in time. What they're learning is that there's reasons why she may respond differently than the average person. And they need to consider that when they're assessing what happened and reliability. And that's critical information that they need to know as they're assessing the case. I mean, without it, it's just, is she lying or telling the truth? But there's another, reasonable possibility here that's grounded in her unique medical profile that makes her different than just an average person.
Could the defense have asked for a forensic psychiatric examination of JF to determine whether she in fact, for example, had flashbacks, whether she in fact had PTSD, the nature of the flashbacks, how common they were for her, that sort of thing? Could the defense ask for that?
I don't know that we could have. I mean, I don't think the defense understood that to be part of sort of the limited remand to do the Daubert hearing, but I will also emphasize that one of the things, that we heard repeatedly from Dr. Raffanello and Dr. DeWright agreed, and I think even Dr. Satoff agreed, is that, when somebody, you need to first, in order to sort of assess and diagnose PTSD, it's important to sort of form that therapeutic alliance. That's why it's not done in an emergency setting. It's sort of done in outpatient care. That's what they were trying to do in Pittsburgh. That's why when they were trying to do it during outpatient care. I don't know that somebody can just come in, on a one-off meeting and do this diagnosis without risking destabilizing a person. So I don't think so. And I also want to say in Polk, one of the things that the court emphasized, this is that Massachusetts case, when they reversed, was that it's sort of, that was not really typically in the option set to sort of force a complaining witness to submit to a psychological examination they don't want. And I would note that, at the time of the trial, she was represented by counsel who was objecting to even the disclosure of her medical records. I think that a rule that, a defendant has to force a complaining witness to do something she doesn't want to do would create all sorts of other problems. And I don't think that this court should go there. And that's certainly not what Polk says. And so, I know I've talked for a long time. I have not addressed sort of harm from the masturbation evidence. I'm happy to address that, or I know I've been.
Well, we've gone on for quite a bit. Let us hear from the government, and we'll be generous within reason for rebuttal.
Thank you.
Mr. Lenners.
Thank you, Your Honor. Good morning, and may it please the court. My name is Dan Lenners, and I represent the United States. The trial court did not abuse its discretion either.
Mr. Lenners, you're very faint. I'm sorry. Could you get closer to the mic?
Sorry, is that better?
It is.
Sorry about that. Dan Lenners for the United States. The trial court did not abuse its broad discretion in determining that Dr. Raffanello's proposed testimony did not meet the Daubert criteria and was inadmissible under Rule 702, and likewise did not abuse its even broader discretion in finding that the minimal probative value of that testimony was outweighed by the serious prejudicial effect that would arise were this testimony to come in, thus laying out the JF's complete psychiatric and sexual history to the jury, causing a mini trial about her psychiatric and sexual history rather than a trial about whether she was raped on the day in question. I think it's important to emphasize the lack of fit between the facts of this case and the expert's proposed testimony.
Can we start there? Sorry to jump in, but you've just highlighted that our review is for abuse of discretion. And we sent this back for a record remand with some pretty specific directions to the trial court, one of them being to describe what the proffered expert testimony was. And I'm looking at the court's ruling, which I thought surprisingly came after a 3-day hearing where 3,000 pages of medical records were discussed, and there was not a pause in the proceeding before the court just ruled from the bench. I don't see a description of the proffered opinion testimony. And it seems like that needs to be the first thing that the court describes before it goes on to do its 702 analysis.
I think the trial court accurately described Dr.
Can you show me where the court describes it in its ruling?
Yes, Your Honor. On page 141 to 142 of the April 7th transcript, the trial court said, Dr. Raffanello was clear, it's possible, meaning it's possible that JF suffered a flashback to a prior rape during the incident in question. And he went on to say, but she could not give us any information regarding the probability of that possibility coming into being because she can't. And then
it's not really a description, right? I mean, a description of the opinion testimony is this expert is going to say that this witness had, based on the medical records, undiagnosed PTSD or subsyndromal PTSD, that undiagnosed PTSD or subsyndromal PTSD based on her clinical experience, manifested in, flashbacks around the time of the incident as documented in the records. And, third, that, she thinks it's possible that there was an actual flashback on the date of the incident to a prior rape. It's just that it's not described anywhere. And it seems like that's important for the reason that I was discussing with Mr. Thompson's counsel. It seems like you need to actually understand the full scope and the components of the expert testimony before you can do a 702 analysis, because it seems like the first two parts of the analysis that this individual, there's a reasonable alternative explanation, a differential diagnosis that this individual had PTSD or subsyndromal PTSD. That seems supported by both the record evidence, the medical records, and the methodology. And I'm not sure that that's even disputed by the experts who testified at trial. Do you agree with that part? Just take the PTSD part.
That it is not disputed that she had PTSD.
But it's a reasonable alternative explanation. I mean, I think that there's testimony from Dr. Satoff that it is in fact possible that that JF had undiagnosed PTSD or subsyndromal PTSD. I think Dr. Satoff admits that.
I don't agree with that, Your Honor. I don't have any recollection of Dr. Satoff agreeing with it. He looked for signs in her medical records that she had PTSD, and he found that her providers who treated her.
He disagreed. He came to a different conclusion, but he never testified, oh, I think the methodology is wrong. I think that this is the way that she's analyzing this is completely bankrupt. I think she has no basis to say this. There's none of that, right? He just comes to a different conclusion based on the same facts and his same review of the same medical records.
He disagreed with her reading of those medical records, meaning
right.
He disagreed with her methodology. He disagreed that you could surmise that something described as tactile hallucinations were in fact a PTSD-induced flashback. He disagreed that a rule-out PTSD diagnosis meant that it was never acted on, as opposed to the fact that her mental health providers had considered it and rejected it. He looked at the fact that she had a stable job, and when he disagreed not only with her conclusion that PTSD was a reasonably probable alternative explanation, which, by the way, is a caveat that she never gave. She said it's possible. She never said it's reasonably possible. She never put any sort of percentage or likelihood on this alternative diagnosis, other than to say, based on her review of the records, it is theoretically possible that JF had undiagnosed PTSD or subsyndrome.
Well, she did give a little bit more than that, right? Dr. Sata or Dr. Raffanello she works at St. Elizabeth's. And she says that she's seen numerous, I can't remember if she gave a number of patients who have SSD. And then she did give some number about how many of those patients have co-occurring PTSD or subsyndromal PTSD. And it was a big number. And then she looked at these records and said, I think it's possible. And I don't think it's a stretch to say she was saying, this is a differential diagnosis that is supported by the records. I do agree with you. She uses the word possible in different places, seemingly to mean different things. But on the PTSD, it seems like that is pretty well supported, and you disagree.
I do disagree, Your Honor. I disagree that that was the conclusion that she stated. She looked at the medical records. She identified an instance of reported flashbacks from 6 years before. She identified instance of tactile hallucinations that she said could have in fact been flashbacks. She identified the fact that JF had prior trauma, and she said that based on those indications in the medical records that it was possible that she had PTSD or subsyndromal. But then she went on to say, I've never interviewed her. I've never had the chance to sit down with her, and that type of step would be
Dr.
necessary.
Satoff didn't interview her either. And yet he purported to opine about whether or not she had PTSD based on the medical records as well. I mean, they both agree that you can look at medical records and you can discern things from those medical records, right?
It's undisputed that you can discern things from medical records, but the fit between that, highly theoretical opinion that she, not only does she have PTSD or subsyndromal PTSD, or the possibility thereof, but also that caused her to have a flashback.
Well, I'm just stuck on the PTSD, and let's remember, I mean, we're looking at a historical fact, right? Like this incident happened in 2016. The trial is in 2017, 2018, right? So, I mean, if we're interviewing JF at that point in time to try and figure out if she had PTSD in 2016, that also seems to have some complications, right? The best evidence might be in the medical records around the time of the incident, which is what both doctors were looking at.
The medical records following the incident, during which she was treated inpatient, showed no indication that she had a flashback at the time of the incident.
Mr. Lenners, may I ask you a question for clarification purposes? This concept of subsyndromal PTSD leaves me a little confused. I'm not sure what it really signifies. Does it signify anything more than that I can't say the person has PTSD, but I do see some symptoms that might be symptoms of PTSD, although of course they might also be symptoms of other things, just as, to illustrate, somebody having a fever, well, that fever might be a symptom of one disease or illness, might be a symptom of other illnesses. I can't say more than that. Is that what we're talking about here when we talk about subsyndromal, this concept of subsyndromal PTSD? Because if that's true, it seems to me a very, it falls far short of a very significant opinion. But I may be underestimating what this concept of subsyndromal means.
That is my understanding of subsyndromal PTSD, Your Honor. In fact, Judge Puig-Lugo specifically asked Dr. DeWright about how to determine whether someone has subsyndromal PTSD, and said, are you applying the criteria for PTSD from the DSM-5 and using those criteria to find that not all are met, but the person has subsyndromal PTSD? And Dr. DeWright said, not exactly. No, that's not how it works. That it's even sort of more vague than that, that you have signs and symptoms of that could be mapped onto PTSD, but could also be mapped on to other mental illnesses. And in fact, that's true of the signs and symptoms in JF's medical records that Dr. Raffanello pointed to. They were almost all, if not entirely, except for the previous flashbacks, symptoms of the schizophrenia spectrum disorders that everyone agrees that she has suffered from for a long time. And Dr. Satoff, in fact, noted that they were pretty non-specific, things like anxiety that could be mapped onto a lot of disorders. But to sort of go back to first principles, even if, and I don't concede this, but even assuming for sake of argument that it would be a 702 compliant expert opinion that JF had, there was a reasonable likelihood that she had PTSD or subsyndromal PTSD at the time of the incident, that still would be an inadmissible expert opinion because there is no link to the facts of this case. And that's
why is that? I mean, if the testimony were just, she has what appears to be a differential diagnosis of PTSD, and she is having flashbacks around the time of the incident, right? I mean, in November, in January, in March, the incident's then in August, and then in the subsequent March, in this case, there's another rule out diagnosis of PTSD that follows months later, right? So to the extent that the trial court said PTSD was considered and then rejected, that's just wrong, given the medical records. So if we have that, why is, and nothing about the actual date of the incident, why is it a 702 problem to admit that expert testimony?
Your Honor, there's a lot in your question to unpack that I think doesn't accurately represent the record here. There were not hallucinations in November 2015, January 2016, or March 2016. There were indications.
There are notes of trauma-induced psychosis.
There were.
And then there's a rule-out diagnosis of PTSD in November of 2015 and a rule-out diagnosis of PTSD in March of 2017.
And that is not active hallucinations. Those are references to past hallucinations. The only report, flashbacks. The only report of flashbacks, of actual flashbacks by this victim, were that she experienced flashbacks following the rape that occurred in 2014. So there were not active flashbacks in November of 2015, which was a premise of your question.
Fine. So there's an indication that she's having tactile hallucinations, which could be an actual flashback, not a hallucination 6 weeks before the incident. But put that aside, assume for the moment that there is substantial evidence to support expert testimony of a possible PTSD diagnosis or subsyndromal PTSD and the occurrence of flashbacks within weeks of the incident. Just assume that is true. Why is it a 702 problem to admit that testimony?
Because there's no fit to the facts of the case. And there's
Are you saying it's not relevant?
I'm not saying it's not relevant, Your Honor.
Does it have to be helpful to the jury to pass muster under Rule 702?
Yes, Your Honor. Under 702A, it has to be helpful to the jury. And the Supreme Court and this court have both said that gatekeeping inquiry has to be tied to the facts of a particular case. And it has been described in all of the cases as one of fit, that scientific validity for one purpose is not necessarily scientific.
Okay, so say I have evidence and I can put on an expert that shows that a complainant had PTSD and had a flashback to a prior rape the day before the incident. Would you still say that it's not helpful, there's no fit, it's not relevant?
That would be a different case than exists here. It would be a harder case, but the jury still needs the tools.
Well,
to
I guess I'm trying to figure out like what the fit is, like, why not a why not a flashback within 6 weeks? Why does it have to be the day before?
Because you need either the expert to tie the facts of the case to a flashback, or you need the jury to have the tools to do that, and neither exists here.
Why couldn't a jury say, here's a person who keeps having flashbacks, who has untreated PTSD, and who is going into the hospital, stabilizes, gets these rule out diagnoses, and then is released and decomposes again? Why couldn't a jury look at that and say, that's interesting information that I'd like to consider and would be helpful to me in considering whether or not this person is a reliable reporter of the events on the date in question?
Because there's still no specific ability for the jury to draw the inference that a flashback occurred on this date. The expert did not give an opinion.
What is the case that says that they have to be able to draw the link to this particular day?
That's what I draw from this court's cases in Ben, Mindome, Nixon, where they all say, Ben, for example, says not all expert testimony concerning the potential unreliability of eyewitness identification is relevant, even if the government's evidence includes identifications. That must be evaluated with care in the context of the particular case. Mindome tied the admissibility of expert testimony.
I'm sorry, can you read the Ben quote again? I didn't quite understand what the point was.
The point is that just because you have an eyewitness identification in a case doesn't mean that expert testimony about unreliability of eyewitness identification is necessarily relevant or admissible, that it must be tied to the facts of the case. There must be a link, there must be a fit. And that's the same.
Right. I mean, if you want to put on expert testimony about weapon focus, you better have a weapon in the case. I get that. I mean, here, if you want to put on testimony about the complainant having, an individual having PTSD and flashbacks, it better be the same person that experienced the crime. I'm not sure that it says much more than that.
I disagree, Your Honor. It suggests that the jury has to have the tools to be able to apply the opinion to the specific facts of that case. And here the jury would have been left with no ability to do that. Dr. Raffanello gave no testimony whatsoever about how to evaluate whether a person has had a flashback or not. The jury would be left with this gaping hole between it's theoretically possible that this victim had undiagnosed PTSD or subsyndromal.
I thought her testimony was the problem is that hallucinations and flashbacks look so much alike, especially for a person in crisis, that even experts have a hard time telling the difference.
But she gave the jury no evidence to even know.
I mean, it's not a question of no evidence. It just seems like that's a possible reason to doubt.
No, Your Honor, because she gave the jury no ability to evaluate whether this victim had anything that looked like, say, even a hallucination or a flashback. I mean, there's been no suggestion that this.
I thought she testified about the victim, the complainant, experiencing the tactile hallucinations, seeming to like react physically to something that just wasn't there, and that was consistent with her kind of re-experiencing an event. I mean, she was talking to them about what it was like.
Dr. Raffanello testified that part of her opinion that the victim may have had undiagnosed syndromal PTSD was based on visual and tactile hallucinations. Visual and tactile hallucinations are not symptoms of PTSD. They are symptoms of schizophrenia. And what she then did was surmise that it was theoretically possible that what was described as a tactile hallucination was in fact a flashback.
So you keep saying theoretically possible when you're describing Dr. Raffanello's testimony, and that's not her term, it's yours, unless I'm mistaken. And so it's similarly to, the characterizations of her testimony as, a reasonable alternative hypothesis, also not her testimony. Does she somewhere say, well, yes, I'm only talking about the theoretical possibility? Or is that your gloss on her testimony?
Your Honor, that is my gloss on her testimony. And the reason for that is because her opinions at each step are contrary to the weight of the evidence.
Well, that makes, I mean, that's a tough, if your point is the trial court should have excluded this because it found on the question, on some like the questions of whether there were signs of PTSD here, that Dr. Raffanella's testimony was so off the wall that it really shouldn't appropriately come in. I'm not sure that was that subsyndromal PTSD, the trial court's line of thinking was like that. But on kind of signs of PTSD, I didn't understand the trial court really to say this is just outside the bounds of reasonable scientific thought.
No, Your Honor, I'm sorry. I was trying to say something different, which is that even under Dr. Raffanella's own opinion and her description of the likelihood of these things happening, she recognized that they were unlikely. She said that only 30 to 40% of people who have PTSD, full-blown PTSD, have flashbacks. She said that typically a person with PTSD who has a flashback knows that he or she has had a flashback. So even under Dr. Raffanella's own opinion, the ultimate conclusion that it was possible that JF had a flashback to a prior trauma, never realized it, that flashback only affected her ability to distinguish consent from rape. And all of that premised on this idea that she in fact had some sort of PTSD or subsyndromal PTSD and experienced a flashback. Under Dr. Raffanella's own account, that was extraordinarily unlikely by her own testimony. And so the trial court was well within its discretion to recognize that speculative leap from the underlying facts to the ultimate conclusion that Dr. Raffanello was going to testify, and that the jury would have to find for this evidence to be material and relevant. The jury would ultimately have to conclude that there was a flashback here and that it worked.
I don't think that's quite fair. I assume that the jury's task would be to determine whether that was sufficiently possible as to give rise to reasonable doubt. I don't think they'd have to actually find that there was a flashback.
I mean, that might be right, Your Honor, but it's still incredibly speculative.
It might be right, or you think it might be wrong also?
I'd have to think about it, and I'm not sure.
I mean, it has to be enough to give a reasonable doubt as to the ultimate question of guilt or innocence. Each individual, who knows how you evaluate each individual piece of evidence. Certainly, it's a fair statement to say that the expert's testimony has to be sufficient for the jury to find some reasonable degree of possibility that that's what really happened here, that there was a flashback and the flashback was so serious that it impaired this with JF's ability to recount accurately what happened. If they can't come to that level of, if they can't assess the evidence in that light, then it's completely irrelevant.
I agree with that, Your Honor. And in Parker, this court said with regard to this type of mental health evidence that it's only relevant to credibility when it is shown to have a serious impact on the witness's credibility. And so it seems to, with regard to highly prejudicial and potentially misleading mental health evidence such as this, that there is a higher standard, whether that's under Rule 702 or Rule 403 is somewhat irrelevant because the trial court here would have properly excluded.
By the way, this reminds me of something I wanted to ask. Dr. Raffanello, I think, referred to a report or a case in which a person had a flashback to a sexual assault that the person had endured during consensual sex with someone. What do we know about that report? I mean, I'm trying to get a sense of how fanciful the defense theory is here. And I wondered, are there really any reports in the record in medical records or in cases of people who had consensual sex with someone, and during which they had a flashback to a to a prior sexual assault, so that so impaired them that they could not, that they reported themselves as having been raped when they were really engaged in consensual sex. I'm interested in knowing if that's a really fanciful reconstruction or something that is a real possibility. There didn't seem to be much in the testimony on this, but I thought there was some reference to that.
My recollection, Your Honor, is that Dr. Raffanello reported a she reported a person who had a flashback to a prior rape while having consensual sex with a boyfriend, but was able to recognize that as consensual sex and not rape. And so I do think that it is fanciful, and I don't believe that either Dr. Raffanello or Dr. DeWright pointed to any instance where something like this type of flashback actually occurred in their experience or in the literature. They opined that it was possible. Dr. DeWright testified a lot about memory and trauma and how that works. But neither of them pointed to any instance, at least in my recollection of the testimony, where a person experienced a flashback during consensual sex and was never thereafter able to remember that it was consensual and not rape. I mean, it really is a incredible threading of the needle of a type of flashback, because a flashback is typically a flashback to a prior trauma. So something about the prior incident enters the person's mind. So this is, what I think they called a disruptive or intrusive memory. And it would have to be a perfectly sort of placed intrusive memory that JF accurately described that the events leading up to the rape, including being pulled into the woods by the defendant, dropping her cup and phone and purse into the street along the way, was able to describe accurately what occurred in the woods, including him taking off his shirt. And then the only thing that she misperceived afterwards was that she had agreed to all of this and was not raped. I mean, it really is a huge speculative leap. This is an abuse of discretion standard. As the Eighth Circuit recognized in Philip Morris, courts owe great deference to a trial court's finding that expert testimony is unduly speculative under Daubert. And here I think that there is the district or the trial court did not abuse its discretion by finding this testimony inadmissible under 702. But even if the court disagrees, the trial court's Rule 403 ruling is equally not an abuse of discretion, as both this court.
Could you speak to the question also while you're up there, if I may shift our focus a little bit, to the question of whether under a Kadiaka standard, even assuming that it was error to exclude Dr. Raffanello's proffer testimony and combining it with the evidence of Mr. Thompson's behavior after his arrest, could you, which we have previously said should not have been admitted, could you address the harmlessness question?
Yes, Your Honor. So first of all, for all of the reasons we've discussed, the expert testimony was minimally probative. The jury would have been left to speculate about the hypothetical possibility of this sort of perfectly placed flashback under the circumstances of this case, with no evidence that such a flashback actually occurred.
I'm sorry to interrupt. I know you're answering Judge Glickman's question, but can you just point to me where, since we're reviewing for abuse of discretion, we should be looking at the court's 403 ruling. Can you show me where that 403 ruling is?
Yes, Your Honor. The court on page 142 to 143 began describing the type of harmful, prejudicial evidence that would come in, and then said, as far as 403, any claim after having experienced the last 3 days that raising this issue in trial does not represent the mini trial within a trial makes no sense. And so that encompasses, my understanding is, not just the fact that there would be competing expert testimony, but the substance of that testimony, meaning Dr. Raffanello's opinions
I mean,
were
it's pretty
based.
short, right? The 403 analysis, it's kind of breezy and talks about this mini trial within a trial, which just seems odd. I mean, yeah, they just had a 3-day hearing with 3 experts and 3,000 pages of medical records, but only one of the experts would have been called to trial to testify at a trial, and her testimony would have been much more contained, I think. That rationale doesn't, the mini trial within a trial is really all I see for the 403 analysis, and it seems pretty weak.
I disagree, Your Honor. First of all, just preceding that statement, the court talked about how you would want to tell the jury that this woman was raped at age 14, that she was malnourished, that she was
That's
homeless.
part of the 702 analysis.
But that statement has very little bearing on a 702 analysis. It's a 403 analysis. It's a discussion of prejudice. And the trial court's an experienced trial judge. He knows the law. He set forth the standards for both Daubert and 403 at the beginning of the hearing. He knows how to do a prejudice versus probative value analysis. And I think he deserves the credit for us to understand that when he's talking about the hugely prejudicial type of evidence that would come in, that informed his Rule 403 analysis that occurred just paragraphs later. And I would point out that it's not just Dr. Raffanello that would testify. The government would have to respond to that testimony. So the government would put on Dr. Satov. The government would also have to call JF's many mental health providers to rebut many of Dr. Raffanello's suppositions. For example, that JF's actual doctors had not adequately explored the possibility of untreated PTSD, to explore this idea that these tactile hallucinations were in fact a flashback. And they would also have to talk to JF about her entire sexual history to explore the possibility that consensual sex has prompted a flashback. I mean, this would be hugely prejudicial, and it would be a mini trial about her sexual and psychiatric history that would overwhelm what truly is the point of the trial, which is to determine whether the defendant is guilty of rape. In terms of the harmlessness analysis, Judge Glickman, the probative value of the expert's testimony is almost non-existent. And even if accepted, there is no explanation for both the pre-rape evidence and the post-rape evidence, meaning Kevin Thompson was a complete stranger. He followed her home from her first week at the job, where she was still wearing her work clothes and was tired and wanted to go to work the next day. He was following her down the street, and she told him to get off and stop following her. He then grabbed her and dragged her into the woods, causing her to drop her juice in the middle of the street, her phone also in the street, her purse filled with her important papers such as her social security card, and a single shoe in the grass embankment leading into this trash-filled woods. So you begin by this incredibly unlikely circumstance that she agreed to have consensual sex with a complete stranger under those circumstances. And then you have evidence that is not at all, cannot at all be addressed by consent, which is that she tossed her phone in the street because she was so excited to have consensual sex. Like, she took off a shoe on the way. She was sort of flinging her belongings in excitement. The expert testimony cannot explain that at all. And it fully corroborates JF's testimony that this was rape. And then after the rape, you have Thompson's evidence of guilt, which is, as a woman is screaming at him, "You raped my daughter, you raped my daughter," with his shirt that he left in the woods, he just kind of starts walking away. That's not evidence of innocence. That's not how a person who just had consensual sex reacts. And then when Montreal Black comes to talk to him and says, "That woman is saying you raped her daughter," he lies. And he says, "That's my girlfriend's mother," which is pretty compelling evidence of consciousness of guilt. And the defense's response to that is incredibly weak. They say, well, she didn't have the injuries you would expect because she said he was choking her. But the government's expert testified that in many, if not the majority of choking incidents, there is no visible evidence of choking. They pointed to a single neighbor who said he didn't hear her screaming, but the evidence at trial showed she had a very soft voice, and that neighbor also didn't hear all of the EMT and police that arrived. He said he didn't hear anything that night. And so if you have police and sirens on that street arriving and he didn't hear those, the fact that he didn't hear her screaming is effectively meaningless. And so regardless of whether it's just the masturbation evidence or the masturbation evidence in tandem with this, minimally probative, nearly meaningless expert testimony, we think that any error here is harmless under Kodiakos. I see that I've given a little bit of speech. My time is up. We would ask that the judgment of the trial court be affirmed.
Thank you. We'll hear now from Ms. Schneider. Ms. Schneider will give you a few minutes in rebuttal.
Thank you. I just have 2 points on harm, one related to each error. First, the jury does not have to determine what actually happened on the night in question. It has to determine whether the government proved its case beyond a reasonable doubt. And this expert testimony from Dr. Raffanello about flashbacks and PTS very, very well could have raised a reasonable doubt that Mr. Thompson forcibly raped her. But I also want to remind the court that there is another error in this case that we have not talked about today, and that error, the erroneous admission of graphic evidence that Mr. Thompson disrobed, masturbated, and ejaculated while under video surveillance, is an independent basis to reverse Mr. Thompson's convictions. That evidence was singularly devastating because it depicted Mr. Thompson as a sexual monster who was out of control and could not control his urges. I think the notion that he would masturbate at the police station immediately after being arrested for first-degree sexual assault and without regard to the video surveillance, the reality that an officer could walk in at any moment, the fact that he's leaving semen on the floor, that would be shocking to most jurors and confirmatory of the sexual assault. It invited the unmistakable propensity inference that because Mr. Thompson could not control his sexual urges in a heavily scrutinized police setting, he was the type of person that would commit sexual assault. I know this court has already recognized that prejudice in its 403 analysis, but it was overwhelmingly powerful here in this case because the government bookended the case with that evidence. They opened on Mr. Thompson's masturbation, priming the jury to view him through that lens. And it was the final evidence the jury heard before going back to deliberations. The stipulation that was read was 3 paragraphs long. It was sent into the jury room as an exhibit that they could read, over and again. And this, we believe that this vivid and graphic evidence is the type that would cloud a jury's deliberations, make JF's allegations seem more credible, and interfere with the jury's ability to fairly consider Mr. Thompson's defense. And that was just compounded further by the fact that Mr. Thompson could not put on. Yes.
Counsel, did the stipulation come before or after the government's closing? It came before, right?
It came before. It was the final piece,
the last piece
of evidence that was read to the jury before the closing arguments.
If I recall correctly, there's no mention of the stipulation in the government's closing. Rather, the government's closing focused on all of the evidence that Mr. Leonard's just summarized for us. Can you talk to us about how you assess harm in light of that evidence?
Sure. I mean, they didn't, right? They didn't focus on it in closing, but the damage was done. I mean, it was done by opening. It was done by the stipulation. I don't know why they didn't close on it other than to think that it seems like they recognized at some point that maybe they were going too far. I mean, originally they were going to show a video to the jury and then instead we give the stipulation. I think maybe that's just evidence of sort of the prejudicial nature of it. But I think the fact is that's what the jury hears. They hear it as a statement of uncontroverted fact, right? Unlike other evidence in the case that's disputed, this is the one piece of evidence. It's read as this long stipulation in graphic detail as like something that absolutely happened. And it's what it's the very last thing the jury hears. And so we think that has a lot, that's very powerful. And the government didn't need to argue it in closing for it to have the desired impact, which is to really the jury see Mr. Thompson in an entirely different light and in a prejudicial light that makes them think this is the kind of person who would rape someone. He cannot control his urges. And I think for some jurors, they're going to just not do the hard work of analysis, right? They're not going to think too hard about all the other inconsistencies that I was pointing out earlier. And when I mentioned that nobody heard, her screaming, I'm not only talking about the defense witness that we put on. I mean, the evidence was that there were lots of neighbors. This is a neighborhood, the lights were on. The government put on no evidence of any other ear witnesses who would have heard what was going on. So it's the defense put on one witness who didn't hear anything, but also the government didn't try to corroborate that in any way. And so, we think that the jury just isn't going to be thinking about things like that once they've heard this evidence that the government opened on, and they're going to be seeing Mr. Thompson through that light. And I think that independently is a basis to reverse. The government can't show that the judgment was not substantially swayed by this highly, highly prejudicial error. And then also it is compounded by the fact that the defense could not offer its theory of the case, which is that JF had a sincere but mistaken belief that she was raped. And that could be explained by her, specific mental health history that included a prior history of flashbacks to a prior rape and tactile hallucinations just 6 weeks before.
Can I ask you just on the possible harm of an error relating to the exclusion of Dr. Raffanella's testimony? I just wanted you to address that question in light of the answer that's been referred to, that's on page, 127 is the question, and over to page 128 of Dr. Raffanella's testimony. Because the question that's asked is, you're not aware of any evidence that suggests that JF actually suffered a flashback on August 22nd, 2016, are you? And the expert says, I have nothing to believe that, no. So if I'm calling an expert to try to persuade the jury to have a doubt on a topic, and the expert's testimony would be, I have nothing to believe that, that doubt, I have nothing to believe that doubt is warranted. It's hard to leave aside admissibility. It's a little hard to see how a reasonable jury would respond to that by saying, oh, I guess I should have a doubt on that topic. So can you try to
Sure.
harm in light of that?
Yeah, so I think that goes to the distinction between, testimony about, opining about what actually happened on a particular night and purporting, to take on that role and say, I know what happened versus, expert testimony about what would be possible for somebody with a particular, medical profile. And I think that, I think the defense would explain to the jury, if this is if this were a concern, would explain to the jury what she said, right? Which is, I'm not opining on what did or did not happen that night, right? That's not my role. She says at one point, my role was to talk about the possibilities regarding someone with this sort of diagnosis and types of symptoms. I don't know what happened, and I wasn't there, and I don't feel it's my role to opine as to whether or not the event occurred the way either side is positing. I think that's at page 111 to 112. And I think what the defense is offering to the jury is, jury, it's your job to decide, what happened that night and whether or not there's a reasonable doubt, right? It's your job to decide, and they would point to all the different evidence that supported the consent theory, but they'd make clear what the expert witness is telling you is that this is not just an ordinary random person on the street. This is someone who has previously had flashbacks to a prior rape. This is a person who was having tactile hallucinations, right, 6 weeks earlier. And doesn't that give you a reason to doubt that that's what happened here, particularly when we look at other, pieces of her testimony that frankly are not corroborated by any other evidence and just don't sound like a rape? Let me put down my t-shirt, make you comfortable. It's going to be asking the jury to do sort of a fulsome review. But I think the difference is that without this evidence, the jury is left with, she's lying or she's telling the truth. And that's not really the defense theory, but they weren't able to offer the jury this other possibility that is unique to her based on her medical profile that would not be available for the random person on the street. But she's not the random person on the street. She has this unique history. and of rule out diagnoses, et cetera, that we've talked, ad nauseum about.
Okay. Counsel, thank you both. The case is now submitted and you may log off.
This honorable court is now adjourned.